You are not alone. Trinity AI. Trinity AI Legal. Trinity AI Helix. Trinity AI Support. Trinity AI Design. Courtesy of White Rabbit Studios.
Hi, it's Adam right here from Trinity Helix. Just to let you know, here's an example of one of the underlying data sets that we've used to create Baxter. You can see it's a Google Deep Research report. In this case, it's looking into the example of how to act in court as litigant in person.
Well, a pretty tough but really crucial topic: navigating the civil and family courts in England and Wales if you don't have a lawyer.
Yeah, going it alone.
Exactly. And our main guide for this is the official Court Guide for Litigants in Person. It's basically designed for people in exactly that situation.
It is. And our mission today really is to cut through some of that complexity. Give you the essential info, the procedures, who's who.
Make it feel less daunting, hopefully. Give you a bit more confidence if you're facing court by yourself.
Precisely. We want to pull out the key things, maybe even a few surprising bits to kind of shortcut that learning curve.
Okay, so let's start right at the beginning. Why do courts exist? What's their basic job?
Fundamentally, they're there to sort out disagreements when people can't sort them out themselves, applying the law to the facts,
Makes sense. And the structure now?
Yeah.
Is it complicated?
Actually, it's been simplified quite a bit. You've basically got a single county court system across England and Wales for most civil claims, things like debt recovery, contract disputes, housing issues, personal injury, up to about £30,000.
Okay.
And then there's a single family court structure that deals with all the family stuff, children arrangements, financial settlements after divorce, domestic abuse applications. Those are the main ones you, as a litigant in person, are likely to encounter.
Right. So if you are heading into one of these courts without a lawyer, what are the rule books, the sort of rules of the game?
Ah, yes. You need to know about the CPR, the Civil Procedure Rules for civil cases.
CPR. Got it.
And the FPR Family Procedure Rules for family law cases. Now, these rules, they're actually intended to make things more efficient, fairer, and even accessible for non-lawyers.
Accessible. Okay.
How so? Well, the big principle underpinning them both is called the overriding objective.
The overriding objective. Sounds important.
It is. It basically means the court has to deal with cases justly and at proportionate cost.
Justly and proportionate cost. What does that actually mean in practice for someone on their own?
It means trying to ensure fairness for everyone involved, putting parties on an equal footing as much as possible.
Even if one side has a lawyer and the other doesn't?
Yes, that's the aim. It also means saving expense where possible, making sure the costs involved are, proportionate to what the case is actually about.
Right, not spending thousands arguing over a few £100.
Exactly. And dealing with cases quickly, efficiently, allocating the right amount of court resources. It leads to things like judges actively managing the timetable. They don't just let things drift.
Active case management.
Yes, and encouraging cooperation between the parties, pushing towards alternative dispute resolution, mediation, things like that. But, and it's a big but, it also means you have to comply with the rules and any orders the court makes. There can be sanctions if you don't.
Okay, so despite the aim of simplicity, it's still complex.
Oh, absolutely. It can still feel very complex for litigants in person, no doubt about that.
And it's an adversarial system, right? Each side puts their case forward.
Correct. Each side presents their evidence and arguments. The judge is there as the impartial referee, deciding based on the law and the evidence.
But if one side doesn't have a lawyer, does the judge help them out?
Well, yes and no. Because of that overriding objective, the judge does have a duty to help a litigant in person understand the procedure.
Procedure, okay.
So explaining what's happening in court, what you need to do next, making sure you have a fair chance to present your case. But what they absolutely cannot do is give you legal advice. They can't tell you what arguments to make or what evidence is best. That's not their role.
That's a really critical distinction. Procedure help? Yes. Legal advice? No. Okay, so who else is in the courtroom? Who do you need to know about?
Right, key players. You've got the judiciary. This could be magistrates. They're often volunteers, especially in the family court, and they have a legal advisor assisting them. Then, district judges handle the bulk of the work in both county and family courts. And for more complex or serious cases, you might have a circuit judge. You'll pick up how to address them, usually sir, madam, or your honor.
And court staff.
Crucially, the court usher. They're often your first point of contact at the courtroom door. Definitely find them and let them know you're representing yourself. They can be really helpful.
Good tip. Anyone else?
You'll see a court clerk usually sitting near the judge taking notes. Security staff, obviously. And then there's the other side. If they have lawyers, remember their duty is to their client, not to you. They won't give you advice.
Makes sense. What about support for the litigant in person?
Okay, good question. There's support through court. They're a charity offering free, practical, and emotional support. They can help you understand the process, fill in forms, navigate the building, even sit with you in court, but no legal advice.
Practical help, not legal strategy.
Exactly. Then there are Mackenzie friends. This could be a friend or family member or sometimes someone you pay. They can sit with you, take notes, quietly offer suggestions on procedure, provide moral support.
Can they speak for you?
Generally, no. They don't usually have a right of audience,
Yeah.
and they can't conduct the litigation for you. Also, be aware, especially with paid ones, they're often not legally qualified, and the area isn't formally regulated, so there are risks.
Okay, caution needed there. Anyone else, particularly in family cases?
Yes, in family court cases involving children, you'll likely encounter a CAFCAS officer. Their role is vital. They represent the child's welfare and interests to the court, not yours or the other parents.
Right, focus purely on the child. Okay, let's switch to civil cases in the county court. You mentioned tracks earlier.
Yes, case allocation tracks. It depends mainly on the financial value and complexity. The small claims track is generally for claims up to £10,000. It's meant to be simpler, less formal, and crucially, cost recovery is very limited.
So less risk of paying the other side's big legal bills if you lose.
Generally, yes. Then there's the fast track, for claims between £10,000 and £25,000. This is more formal, follows a stricter timetable, and costs are usually fixed to some extent.
Okay.
The intermediate track is newer, for claims from £25,000 up to £100,000 that aren't super complex, more involved than fast track. And finally, the multi-track is for claims over £100,000 or those that are particularly complex, legally or factually. This is much more like traditional high-stakes litigation, high-cost risks involved.
So the track really dictates the procedure and the financial stakes.
Absolutely. It's a key thing the court decides early on.
And what about the actual hearings you might have to attend? What are the common types?
Well, early on, you often have a case management conference, like a CMC or a directions hearing, that's mainly about the judge setting the timetable and sorting out what needs to happen before a final hearing.
Setting the roadmap.
Pretty much. You might also have interim application hearings if someone needs a decision on something specific before the end of the case.
Like a temporary order.
Exactly. In family court, you get specific hearings like the FHDRA, the first hearing and dispute resolution appointment, mainly in children cases, often involves CAFCAS getting involved early.
Okay.
There's the FDR Financial Dispute Resolution hearing, which is a specific type of hearing focused entirely on trying to help the parties reach a settlement on finances, usually without prejudice.
Meaning what's said there can't usually be mentioned later if it doesn't settle.
Correct. And sometimes, if there are serious allegations that are disputed, like domestic abuse, you might have a separate fact-finding hearing just to decide what happened.
Before the main decision.
Yes. And then, of course, you have the final decision-making hearings. The small claims hearing, less formal. A trial in fast, intermediate, or multi-track, much more formal with witness evidence and legal argument. Or a final hearing in family court.
Right. Okay, so if you have to go to court for any of these hearings, what's the absolute number one thing?
Oh, preparation. Preparation. You just can't wing it.
What does good preparation look like?
Read everything. Every letter, every statement, every court order. Organize your papers logically. You might be asked to create a court bundle with all the key documents, page numbered.
Like a shared folder of evidence.
Sort of, yeah. Usually a physical binder or an electronic one these days. Prepare concise notes of the key points you want to make relevant to that specific hearing. Check the logistics court address, which room, how long it takes to get there.
Arrive early.
Definitely arrive early. Dress respectfully, smart casual is usually fine. Arrange childcare well in advance if needed. And importantly, tell the court beforehand if you have any accessibility needs or, crucially, any safety concerns about being in the building with the other party.
Okay, really practical stuff. You get into the courtroom itself. Etiquette, things to definitely do or not do.
Yes, basic politeness goes a long way. Stand up when the judge or magistrates enter or leave the room.
Okay.
Use the correct form of address. Listen to how others do it, but Your Honor for a judge is standard for Sir Madam. Speak clearly. Speak to the judge, not the other side directly, unless you're cross-examining. Right.
Listen carefully when others are speaking. Don't interrupt the judge, obviously. Keep calm, be polite, even if things get tense. Oh, and absolutely switch your phone off or to silent. Completely off is safer.
Good point. Anything else?
Yes, the bowing. It's customary to give a brief bow of the head towards the royal coat of arms, usually behind the judge, when you enter or leave the courtroom.
Okay, a sign of respect for the court when it's your turn to actually present your case or give evidence.
Stay focused. Know why you are there for that particular hearing and stick to the relevant points. If you're referring to your written witness statement, say which page and paragraph number.
So the judge can follow easily.
Exactly. If you're referring to a document in that court bundle, give the page number. If you're asked questions or giving oral evidence yourself, listen carefully, answer truthfully and directly. If you don't know the answer, it's perfectly okay to say, I don't know, don't guess.
Better than making something up. Much better. If you're asking questions cross-examining, keep them relevant, stick to the facts, stay calm, and at the end, you might be asked for submissions. It's basically your chance for a very brief summary of your main points and what you want the judge to decide.
Concise summary. Okay. The hearing finishes. What happens then? What do you need to look out for?
You'll eventually get the outcome. This usually comes in two parts. The judgment, which is the judge's reasoning, their explanation for the decision.
The why.
Yes. And the order, which is the actual legally binding instruction from the court about what must happen, who has to do what, by when.
And the order is the crucial bit.
Absolutely critical. You must read the order extremely carefully as soon as you get it.
Okay.
If there's anything you genuinely don't understand about what it means you have to do, contact the court office. They can't give legal advice on whether it's a good order, but they can clarify the wording.
Okay, and you have to follow it.
You absolutely have to comply with a court order. Failure to do so can lead to enforcement action, cost penalties, or even, in serious cases, being found in contempt of court. It's mandatory.
Right, serious consequences.
Mm-hmm.
So wrapping up, let's quickly recap the support networks again. Where can people turn?
Okay, so definitely remember Support Through Court for that free, practical, and emotional help, brilliant resource, but no legal advice.
Mm-hmm.
Mackenzie Friends can be helpful for notes and support, but be aware of the limitations, especially around speaking rights and the unregulated nature, particularly if you're paying for one.
Caution advised.
Yeah. Court staff can help with procedural questions, how to file a form, where to go, but again, no legal advice on what to put in the form.
Got it.
Official websites like gov.uk and the judiciary website have loads of information. Legal information charities like Advice Now or Citizens Advice can provide general info and sometimes initial advice.
And actual legal help.
Pro bono schemes exist free legal representation, but they are often very oversubscribed and have strict criteria. And then, of course, there are paid solicitors and barristers if your situation allows. Think about maybe using a mix of these, a sort of layered support strategy.
That's a great way to put it. So the big takeaways seem to be prepare meticulously, get your head around the procedure as best you can, and always maintain respect for the court process.
That's the core of it. It's definitely challenging going it alone, no question. But understanding these basics, knowing who's who and what's expected, it can make a real difference.
Hopefully this deep dive has helped shed some light and maybe boosted that confidence level a bit for anyone facing this.
Yeah, and maybe a final thought for you, the listener. Think about that range of free support we mentioned. Support through court staff for procedural things. How might not just knowing about and maybe proactively reaching out to those resources help ease some of the inevitable stress and uncertainty? What steps could you take to build that layered support strategy we talked about, just in case you ever needed it?
You are not alone. Trinity AI. Trinity AI Legal.